So,
The President, please be seated. The chamber is now back in session. Before the adjournment for lunch, the floor was given to the civil lit co-lawyers to respond. And in the morning, we heard the response from two civil party lawyers. For this afternoon session, we will proceed again. However, there are certain circumstances that we would like to inform the parties. The Chamber would like to inform all the councils that in the circumstances where a number of the lawyers, like in the civil parties groups, need to make their presentations, they have to make sure that there is no repetition. You have to allocate amongst yourselves to stand and make the presentations, but the number shall be true, the maximum. And I remind you to follow this instruction. So please, once again, make sure not to repeat what has been said by your colleague already, or what has been in the written pleadings that you already submitted. The floor is now given to the civil party lawyers. Judge Lavenge, you may proceed.
Oui, juste une clarification.
Yes, just a clarification, because I am not sure what you said was clearly translated. Mr. President, the judges are concerned about the fact that some representations may be repetitive. When many lawyers have to speak on the same subject, it would be good to avoid any repetition, and it would also be good that only two lawyers should speak, and this is to ensure that we work efficiently. We are addressing this directive to all the parties.
Medavi.
The President, Council, you may now proceed. Chit Wan Lee. Good afternoon, Your Honors. Good afternoon, everyone. My name is Chit Wan Lee, civil party lawyer. I would like to wholeheartedly express our support to the arguments raised by the co-prosecutors against the accused that 1. A fair judicial system only existed in the mid-90s. 2. The civil war in Cambodia is an obstacle to prosecute the offenders in a fair trial. 3. The obstruction by the accused to be prosecuted, and then also on the existence of the ECCC law. I'd like to express my 3 points as the civil party lawyers in relation to the expiries of the statutory limitation. 1 is the equality before the law. Based on the arguments raised by the defense counsel, they want the perpetrator not to be prosecuted based on the expiry of the crimes according to the Penal Code of 1956. But the question is, will there be a real justice if there is no one responsible for it? If the victims did not be treated equally before the law, as declared that everybody is equal before the law, that is the equality to be treated fairly before the law. That is the constitutional law as well as the international law. However, here the victims are not treated equally, both during the Democratic Cambodia period and during the present time. The ECCC law so responds to the suffering of the victims of the entire Cambodian society who have been waiting in silence that one day the perpetrators shall be fairly prosecuted. Your Honors, I'd like to raise the issue of inequality of the treatment that the accused shall be responsible for the victims during their power. No Cambodian citizen who lost their beloved, who has not lost their beloved family members during the period. After the collapse of the regime, the victims always stick to their view that they do not revenge with another revenge. And they tried not to take revenge for such a suffering. The harms suffered by millions of Cambodian people, including my clients, who were killed, tortured, imprisonment, and other ill treatments, which are the actual facts in providing the testimony to the court, even if the existence of the victims recognized by the ECCC does not respond equally to the total number of the entire victims. Every Cambodian citizen suffered, and they're waiting for this court because they understand that the ECCC will shed light of justice for them to compensate physically, emotionally, and materially that they have lost 30 years ago. The question is, why the four accused were not tried during the time they were in power? The answer is that everybody can understand that, of course, they would not be allowed to be arrested and prosecuted in the case of Saddam Hussein. And here, for the Gaddafi, who has been issued an arrest warrant by the ICC, whether he's willing to be arrested, the experience in the International Criminal Tribunal indicates that those who are responsible for the crimes they committed, they were only prosecuted after they lost their power. And this is what is being doing here at the ECCC. The prosecution of the four accused responds to a fair society that you can't commit a crime, but you will not be escaped from prosecution. Number two, the justice and the responsibility of the offenders. The offenders shall be responsible based on the justice that both national and international societies want. And to what level? That is, they shall be treated equally. On the contrary, the instability in Cambodia, as well as the arguments raised by the co-prosecutor, cannot provide justice to the victims. Justice is not only for the accused, but also needs to be awarded to the victims. For that reason, social justice, that a criminal law can be afforded to a party effectively, is the determination of those who are responsible for the crimes. This is the reasons why Article 3 of the ECCC law extended the time limit of the domestic crimes under the 1956 Penal Code to an additional 30 years in addition to the 10 years period existed previously. In addition, regarding the effect of Article 3 of the ECCC, on the 12th February 2001, the Constitutional Council of Cambodia also interpreted that this article is constitutional. Therefore, Article 3 of the ECCC law, which extends the time period of the crime in violation of the 1956 Penal Code, is just to facilitate the procedure to empower the ECCC to exercise its jurisdiction over the offense and the perpetrators, and it does not affect any substance of the Cambodian criminal law. In addition, the implementation of Article 3 of the ECCC law is the contribution to the development of the criminal responsibility, national and international. In particular, the bringing to trial of those senior leaders of the Democratic Cambodia is a requisite participation and contribution of the ECCC to the criminal law, national and international. If the ECCC pay attention to those who are responsible for the crimes rather than to the time limit of the offense, means this is the balance before the law for both the accused and the victims. On the contrary, if the accused, by the virtue of the time limit of the offense, then there shall be no one responsible for the crimes, and equality only exists in theory. To conclude, if your chamber allowed the expiry of the time limit for the criminal offense, then justice cannot be served to the victims. No one will be responsible for the offense. Therefore, the prosecution of the accused, who are the senior leaders, is the only fair means for a legal society, for a legitimate society, and to mend the psychological wound of the victims. Thank you. The President, Mr. Pech Ong, you may proceed.
Counsel Pech Ong, Mr. President, Your Honors, and everyone around the courtroom. I am the lead co-lawyer representing civil parties. My submission will be very brief. It will be made in for a duration of 7 minutes. My observation will also be made in response to observation made by Counsel Saw Sowan, who indicated that the statute of limitation has already run out and that there should be no prosecution beyond what the time limit already indicated in the statute of limitations. I would like to submit that the statute of limitation is very important, and the limitation itself shall be set for a significant period of time to prevent crimes from happening again, and also to serve the interests for the victims who suffered from the crimes that committed. And of course, statute of limitation may run out, and if the competent authority has failed to implement, to carry any prosecutorial tasks during the given time, because the authority itself has been or has omitted to prosecute the accused or the offenders. It is really important that the court issue a judgment, the judgment which is which serves the interests of both the victims and the accused, and the extension of statute of limitation is necessary and appropriate. Statute of limitations shall run out only when, for example, after the accused person has been convicted and he or she remains at large, and after that time he or she if the statute of limitation lapses, he or she shall not be prosecuted. But in this particular case, the accused persons have been well known, and we have already been familiar already that they have never been regretful. They never say sorry for the crimes they could have committed, and the statute of limitation may lapse for example, if the evidence has been destroyed, or because the time has passed and that people's memory is poor. But when it comes to the case before this tribunal, evidence is well collected, and that it is really important to find justice for the victims, the survivors of the regime. The Constitutional Council already ruled that the extension of the statute of limitation, as my colleague already indicated, is constitutional. And there was no prosecution so far against the accused person during the past, and I would not like to repeat this since my colleagues already indicated clearly, and since the evidence has already been well collected, and that the accused persons are well known, and the statute of limitations can be extended and we need to find out who is actually behind the heinous crimes committed during the Democratic Cambodia. The President, could you please hold on a moment? The President, Council Pick Ong, you may now proceed. Council Pick Ong continues. The extension of the statute of limitations before this tribunal is appropriate and justifiable. I would like to submit as well that the pre-trial chamber, the trial chamber, can apply the statute of limitation. Thank you. The President, thank you, Counsel, for the oral submission. We would like now to proceed to the Defense Counsel for any reply if they would wish to do so.
Good
afternoon, Mr. President. Good afternoon, Your Honors, and good afternoon to everyone in and around the courtroom. I do have a reply, and because there were so many different arguments, some overlapped, it will not be sort of a classic reply, but rather I will try to touch upon the block issues that were raised and hopefully get through it all. First, I would like to begin by addressing some of the very passionate oratorical speeches that we heard, primarily from the civil parties, and we wish to convey the following. We agree that this is a special court created by special law, and we all are in agreement that fairness should be for all, and that the laws should be interpreted to ensure that all parties benefit equally under the law, although we do recognize and stress that some parties have different rights than others, but all should enjoy equal protection under the law. We disagree that victims and civil parties should benefit because if the law goes against them, then there is no reparations, there is no justice to them. We're not suggesting that they should not benefit, that they don't have reasons to be concerned. But what we are saying is being a victim in and of itself is not a justifiable reason not to apply the law, however inconvenient the result may be. And I also want to stress that what we're doing here today, and in the past few days, and perhaps in the following few days, we're trying to figure out the contours of the law as it exists and should be applied before this tribunal, because this is a special court created by a special law, and that's what we're doing. We're trying to do our jobs to ensure that we know what the law is before we go forward. We're not trying to deny anybody anyone's rights, but we are trying to figure out where the contours of the law is, and we hope that everyone understands that and appreciates the reasons why we, in particular, the Inc. Suri Defense, have filed, I could easily say, an unprecedented amount of written pleadings in this case. It is not for the purposes of a rupture strategy, and I mention that because I believe that word came from the civil parties, not today, but yesterday or the day before. That is not our intention. Now, moving on to the reply itself. As I understand it, one of the reasons, or justifications, I should say, for that is being presented by the prosecution and the civil parties is that the court system was not functioning. And they gave a variety of reasons, such as the decade destroyed the judicial system and targeted lawyers and judges. After 1979, there were only decree laws, mostly focusing on betraying the revolution. Drafters were former teachers, not legal professions. No right of legal representation of one's choice. No right of appeal, no Supreme Court until 1985. There was no bar association, and so on and so forth. Now, part of this information we received, of course, in my opinion, comes very close to testifying. There may be something in their submissions to justify these assertions, but I do think it is dangerous for a prosecutor to suggest that you judges who have lived through that period, you know best, rule based on your experience. That is inappropriate. Why? It's inappropriate because you must decide this case based on the evidence that comes through the witnesses or through documents that have been admitted. And while you may have special experiences and special knowledge, if indeed that's going to be used in making a decision, one that needs to be shared to all, what that knowledge is, and what your opinion may be, or the facts may be as you understand them, and put them on the record, and two, be subjected to confrontation. Now, I am not suggesting that the judges be cross-examined, but what I am saying that it is inappropriate to say Judges, you know what it was like. There's no need to really move on to that issue, look into that issue. Those are facts. I was here in 1994, 95, 96. I trained lawyers and I was engaged in a court reform project where I went around the country, met with judges, and had trainings. That does not give me the right to give evidence as to what I believe the state of the legal system was, or the capacity of the courts in Cambodia was. That would make me a witness. So I urge you not to rule based on your personal experiences, but based on the facts and the evidence. Now, the very first decree in the RK was Decree Number 1, which established a tribunal that convicted Mr. Pol Pot and Mr. Ieng Sary. We talked about that yesterday. I'm not going to belabor the point. But thereafter, we have records, and we attempted to introduce some of those records from the courts to show that trials were being conducted. The prosecution would have you believe, and the civil parties, and there is some room for flexibility on their part, that there was no functioning judiciary in Cambodia, at least functioning in a sense that you could say that the rule of law was being applied to from 91, 92, and I believe it was 96. These were the years. So as late as 1996, Cambodia did not have a functioning judiciary, and of course part of it was because of the war. Yesterday, we mentioned a document that was presented by the prosecution, that was used by the prosecution in order to establish a point, to clarify a matter. And they referred to Decree Number 28, Council of State, People's Republic of Cambodia. You will recall yesterday we were discussing about the word pardon and amnesty, what the variations. And so they waived this document. This was the document presented last Friday. And they're using this document as proof as to how you should interpret that word, what it actually means. Well, if there was no functioning judiciary, and nothing was functioning, and nothing was proper, and nothing is credible up until 1996, how can they, on the same hand, turn to a document when it suits them, which is 1988, and say, see, this is proof, accept this. Thus far, the prosecution has not, and the civil parties have not presented any credible evidence that there was absolutely no judiciary and nothing could have been done. And we submit that that's an error. With respect to the conditions in Cambodia at the time, during this period up until 96, first let me compliment the gentleman on the prosecution side, which described all of the reasons why the pardon was necessary. And he even used the Prime Minister's strategy, which was the win-win strategy. And at this point in time, because I don't wish to repeat the gentleman's remarks as far as the conditions, the war, the reasoning, all the reasoning behind the amnesty and pardon, why they were necessary, I simply wish to adopt those positions at this point in time for our previous argument concerning why the royal pardon and amnesty were important and necessary. Now, one other point on the judiciary. The gentleman said that, well, the judges were carrying out their jobs with courage and objectivity. Yet at the same time, they would have us believe that not a single case that was being held throughout this time, not a single trial, was a credible one. And we submit that if that were the case, Where has the UN or the NGOs been to criticize all of the conduct of that particular government, the founders of which yesterday, according to the Daily, were celebrating the 60th anniversary of the founding of the CPP? We have no evidence. It is merely an assertion coming from them. But if they were acting with courage and objectivity, then obviously courts were functioning. And a judge cannot be objective if he's not independent. A court cannot be impartial if it is not independent. Was it a perfect situation? No. But if you pick up the newspapers and you read the reports on Cambodia today, you hear the same refrain: political interference, lack of independence, and so on. Not just here in Cambodia, but everywhere else around the world. But does that mean that the judiciary isn't functioning to the point where you could launch an investigation? The prosecution indicated that the 1956 Penal Code was not enforced at the time. And he stated his reasons. Here's our reply. We submit that the 1956 Code was still applicable because it had not been repealed at that time. And it matters not whether the 1956 Penal Code was enforced at any time after 1979. The law that must be applied, and I think we all are in agreement on this one, is that the law that existed at the time when the crimes were committed, albeit with some qualifications based on the establishment law, some of which we have been challenging. Now, the Constitutional Council considered whether extending the statute of limitations contained in the 1956 Code would violate the Constitution. Now, they made their findings, but they made it based on this 1956 Code, which means that it was applicable at the time, and that's the code that you need to look to. A brief remark regarding the Constitutional Council. When I gave my opening remarks today, I had indicated that we differ. We find that the decision made by the Constitutional Council is not a correct one. However, we recognize that this trial chamber and this institution has no authority over the Constitutional Council and cannot overturn one of its decisions. And just as I argued yesterday about the power of law and how we must apply it all the time equally, no matter what the situation may be, we find ourselves in the same situation here today. And we say, yes, we are in agreement. That was the decision. We do, however, submit that there may be an opportunity for you to revisit the issue without necessarily finding that they acted contrary to the Constitution. So let me begin by arguing. I'm going to touch upon, I won't take too much time, Your Honors. Article 3 new of the National Crimes Bullets, okay? This is what we're going to be talking about. Now, they extended the statute of limitations for homicide, torture, and religious persecution under the 1956 Code only, when those crimes are charged in the ECCC. And we've indicated that this violates the equal treatment enshrined in Article 31 of the Cambodian Constitution, Article 3 of the Cambodian Criminal Procedure, Article 7 of the Universal Declaration of Human Rights, Articles 14.1 and 26 of the International Covenant on Civil and Political Rights. We maintain, rightly or wrongly, and you will make that decision, that the Constitutional Council does not appear to have considered this issue of equal treatment when it pronounced Article 3 new in accordance with the Cambodian Constitution. The Constitutional Council's error in failing to consider the Establishment Law's constitutionality in light of the requirement of equal treatment before the law does not mean that the ECC may simply apply Article 3 new. And that's where we're hinging our argument. Granted, it's a very narrow argument, but this is what lawyers are doing when they're trying to define the contours of the law. As a constitutional court, as a Cambodian court, the ECCC is bound by the Constitutional Council's determination that the Establishment Law is constitutional. We're all in agreement on that. However, the ECCC is also bound to respect and uphold all provisions of the Cambodian Constitution, Cambodian laws, and international human rights conventions to which Cambodia is a party. And there lies the friction, there lies the rub, and that's why we're here making this argument today, Your Honors. Not because we're trying to deny anybody of their rights, but because of this. Article 3 new violates Mr. Ieng Sary's right to equal treatment because he could be charged with crimes that a similarly situated Cambodian accused in a Cambodian court would not otherwise face. That's why we maintain that there is a lack of equal protection. The pre-trial chamber found in paragraphs 289 to 291 of the decision of our appeal against the closing order that this argument concerning equal treatment, quote, amounts to challenging the ECCC's limited personal and temporal jurisdiction, end of quote, and that it must determine whether the ECC's limited jurisdiction is out of compliance with the obligations of equal treatment. This is what the pretrial chamber, how they interpreted our argument and what the task was before them. The pretrial chamber found that extraordinary or special courts with limited jurisdictions are not by their nature in violation of the right to equal protection enshrined in the Establishment Law. The pretrial chamber turned the issue into whether the creation of the court with special jurisdiction is a violation of equal treatment. We maintain that this is not the issue. We are not arguing that Cambodia could not create a special court. If we had felt that that was the case, I can assure you we would have filed a written submission. Undoubtedly, and that would have probably been the first one. We have submitted that this court may not apply different substantive laws for every other court in Cambodia, and that's our position. The pretrial chamber found that the ECCC ensures compliance with the fair trial requirements of Article 14 of the International Covenant on Civil and Political Rights because fair trial guarantees have been set out in the Establishment Law and the internal rules. And yes, we acknowledge that. And we have not argued that these guarantees are not set out in the Establishment Law and the internal rules. What we are asserting that these rights exist, while they may exist in law, that in and of itself is a completely different matter from whether the rights are being respected. It's a rather nuanced argument. And again, to clarify points, because I don't wish anyone, whether on the bench or in the audience, to misunderstand the purpose of our filings. Our purpose of our filings is to ensure that the trial chamber has all the necessary tools before it, before we commence the taking of the evidence, that we all understand what the laws are. Since these issues are issues of first impression for this particular tribunal, we have availed ourselves to the laws that allow us to make these submissions and challenges. We are grateful that the laws provide that opportunity. It may seem at times that we overstep our bounds by continually filing submissions. We do not do so to disrupt. We do so because we feel that there are areas in the laws that need to be well defined, and these issues are extremely complex. And again, let me extend my gratitude to the trial chamber for affording us this opportunity to be heard on these matters, and we endeavor never to abuse the discretion that you have granted us in making these oral arguments. Thank you very much.
The President, thank you, Counsel. We note that Counsel Patpal Singh wishes to say something. Counsel Patpal Singh, good afternoon, Your Honors, Mr. President, and the Court. I am Patpal Singh, the National Co-Lawyer for Ieng Thirot. I would like to respond to the observations made by civil party lawyers and the prosecutors concerning the statute of limitations. I have observed that the civil party lawyers refer to the expression of justice. Of course, justice shall be equally treated for every party, the victims and the accused. So since justice is much needed by everyone, then we need to really refer to law as the core principle for finding this justice. The statute of limitations lapsed, and the civil party lawyers and the prosecutors indicated that since the court was not functional at that time, no judges, no lawyer, then such statute of limitations shall be extended. I think it is not really correct to do that, because with reference to the Penal Code of 1956, the statute of limitation for a crime is slated for 10 years, and after 10-year lapse, it lapses. And this crime happens immediately, and the statute of limitation shall start to run from 1979, and that by 1989 it's already run out. The ECCC should really look at the responsibilities of the individual rather than looking into the statute of limitations. This is as what indicated by the civil party lawyers and the prosecutors. And Counsel Pik Ong already indicated that the term of statute of limitation. Now I would like to draw your attention to 1992 when UNTAC came to Cambodia. At that time there was a law, transitional criminal law, and so far as I remember, the final provision states that all provisions that are contradictory to this rule shall be shall be abrogated. So, if such a matter has already been abrogated by UNCTAD law, why should we really review this? In 2004, the law on the establishment of the ECCC was in place, and that the statute of limitations has been extended to additional 30 years. It means that the previous statute of limitations has already run out. I would not like to interpret the decision by the Constitutional Council. But look, in this particular situation, the previous statute of limitations of the crimes already lapsed, and that the new or the extension of such a limitation was reinstalled. From 1979 to 1993, as indicated by civil party lawyers and the prosecutors, of course, there were a shortage of resources, not enough lawyers, prosecutors, or judges. Intellectuals died, and they really made use of teachers to help the court. And it is really what we could do. Of course, at that time, we had to love what we had. And that's all we could do, because that was the ability, that what we could do back then. And the decree law actually was issued by the State Council. At that time, in the Constitution of the People Republic of Cambodia, the State Council was the permanent member of the Assembly. So during that time, the member really issued or adopted this decree law, and this decree law must be applicable, and no one could not really say that it was inapplicable, because at that time our country was the socialist state. And in 1980 there was another decree law, which was decree law number 2 with relation to criminal cases to be applied in Cambodia. In 1982, the law on the functioning of the trial court was established to prosecute crimes, including robberies, and most importantly, crimes concerning the betrayal of the revolution. We had the court. No one could say that there was no functional court at that time. The court was in place, and people who were found guilty and sentenced to death was given 7 days to appeal such a decision. And these provisions, the capital punishment provision, were there. And I can conclude that, of course, there was a court, a functioning court. Whether that court was up to the international standard or not, I think it is still being a matter for further research and discussion. And if we look at the Constitution of 1981 and have it compared with the Constitution of 1993, I think it is really inappropriate to compare the two constitutions, because it's like comparing a palm tree to a human being. Because at that time, when we just emerged from the war and the destruction, then it was the first constitution in place that be applied. It doesn't matter what kind of law being in place, it was already applied and enacted by the State Council, who was the permanent member of the Assembly. And also, our country created several courts and laws and regulations. And again, people were prosecuted, convicted, or sentenced to death and they were executed at Kambol as an example. So we really had a functional court. In 1979, we have a council for people to save people from the war, and that the laws also were in place. I think without such law and provision, country would really be plunged into chaotic situations. I was there and I witnessed everything. And I am very precise when it comes to the existence of the proper judicial system in Cambodia back then. If we look at the retroactivity issue, if the statute of limitations has run out and that it is extended, and of course people need to really apply the principle of retroactivity of the crime. But I think since the statute of limitation has run out, we shall not be looking into trying the crimes that already has its statute of limitation lapsed.
The President. We have a technical issue. The internet is not working, and the IT technicians need to work on that. Also, it is appropriate for us to take a short adjournment. We shall take a 20 minutes break, and we shall resume at 10 to 3.
Song Jing Krao Chong.